All right. So are text messages between an accused and a complainant about sex that they may be having the next day admissible and relevant in a sexual assault trial? Just general proposition.
Well, we have a few cases that say they are. One of the most interesting that came up recently is something that is considered a rape myth, but sometimes might be true.
Yeah, and I just want to say this. So the needle on this moved in Ontario with Rex versus Reimer, which is a 2004 decision. And I'm sorry, I have to give an OJ number 3819, which found that messages prior to a particular...
Reimer's Reimer?
Right.
Yeah.
Found that text messages about what would be the subject matter of the offense would be relevant and capable of being admissible. So this was sought to be...
What year was it?
2024.
24. Okay.
Yeah.
I thought you said 2004. I was like, no, it's a little sooner.
Hopefully I didn't miss. I'm a bit tired, but
2024.
This was, an important.
We talked about this case before.
We did. It's in our newsletter. We talked about it, but it's important just to mention as a pretext.
I know. Sorry, I've got a big piece of lint on my sleeve.
Oh no.
I know. Can't have that happen.
No.
But more importantly, this intriguing case just came up, in which the accused had evidence that the complainant asked him to engage in a rape fantasy.
Yes. I'll have to put it into context, but yeah, go ahead for a moment.
So this is a thing where it's considered to be a rape myth that women engage in rape fantasies. And that may be a rape myth that all women want to engage in rape fantasies. That would be an absolute myth. But some women do. And in this particular case, there were text messages, and this is the case we're going to talk about, RVTS 2025, BCCA 25, in which they sent it back to retrial because there were messages in which the complainant actually asked the accused to engage in a rape fantasy.
Close. Very close. So I've drilled down on this very close because we also reported on this wrote about it in our newsletter. But
go.
let me set this out a little bit, because the trial judge who ultimately convicted and did not allow in the messages did allow in certain conversations. So the judge
post-event conversations, but not pre-event conversations.
Pre-event. So the judge got close. So let me set it up. So the complainant and the accused agreed in the trial that the sexual activity occurred, but disagreed about whether the activity was consensual. And the accused position was that the complainant communicated consent during a conversation before the alleged sexual assault when she agreed to participate in a rape role scenario. That conversation occurred just a few hours, 2 or 3 hours before they engaged in this scenario, where they were talking about, according to his evidence, about a rape scenario where she would feign or pretend to be sleeping, and he would come in and commit and do certain acts.
So this was the conversation in which the scenario was laid out.
Right. Prior to trial, the accused brought a motion to admit certain messages where there were discussions exchanged in these messages the night before the alleged assault about rape play. The testimony was that these messages were followed up with a more specific conversation the next day planning the rape role play. The judge found that the messages were not relevant and could not be admitted into evidence. The judge found the complainant and the appellant never had a conversation about rape role on the day of the assault, ultimately convicted him. On appeal, the Court of Appeal found that the judge erred in holding that the messages were not relevant, set aside the conviction, and sent it back for a retrial. The main issue in this case was whether consent, an honest but mistaken belief in consent, communicated consent, and the messages were relevant to these issues given their content and the temporal proximity to the conversation the appellant alleges happened the following day. So the messages, which was the day before, were temporally and content related to the more detailed conversation that essentially laid out the script for the sex act that was 1 or 2 hours before the actual subject matter of the charge. Okay?
And we've talked about the case of Raymer before, which was kind of similar, in which the Ontario Court of Appeal found that messages related to your agreement of what you were going to engage in when you met with somebody to engage in a sexual act was more or less likely to make it true, right? So I put it that way because that's kind of like the Harris description. But if information, evidence for the court would make it more or less likely to be true, then it's admissible.
So what you're talking about, and this is an important principle, and I just want to pause here and say
Thank
this.
you.
Yeah, no, because so in Reimer there was messages. I keep saying it as the goaltender's name. Could be whichever way. Reimer, Reimer, whatever. Given their timing, context, and content, the illustrative text messages reproduced in certain paragraphs were statements made or adopted by the parties about what they intended to do during their pending meeting. Even though individuals can say things that they do not really mean or change their mind or can engage in fantasy play, okay?
Yeah.
So even though individuals can say things that they do not really mean or change their minds, it is an incontrovertible proposition of logic and human experience that a statement of present intention to do an act at a future time increases the likelihood that the speaker will engage in that act on that future occasion. Because of the sound logical foundation for this kind of reasoning, the law of evidence has recognized a hearsay exception that admits statements of present intention as evidence that the speaker later carried out that intention. That is what you're talking about.
Right.
It's a matter of logic and common sense. It makes it more probable that they may have carried that out.
We're now allowed to use common sense and logic after the decision in Crack from the Supreme Court. So here's the thing to keep in mind. Just because you say to somebody, yeah, I'd like you to have sex with me in a certain way, tomorrow, doesn't mean that you can't change your mind. But those messages can have some evidence circumstantially to make it more or less likely for you to have engaged in those precise acts that you said you wanted to engage in.
So they're relevant to whether communicated consent was given. In the Reimer decision, it was reverted back to retrial. The court did not say that the judge was right or wrong for excluding, left that up for the case to be decided at trial again, but that the logic that was used by the trial judge was incorrect because grounds of admissibility were dismissed. Now, I just want to add one other thing and then we'll go back, because this is important for everybody who wants to understand this, okay? Because in the past, we're always met with arguments that the Crown will oppose such messages.
Still today.
Still today, but it's not as, thank God for these decisions, but the argument from the Crown is consent is subjective to the complainant, and the communicated consent must be to each act contemporaneous at the time of the actual sexual act. Therefore, any prior communication about the sexual act that you may or may not engage in is irrelevant.
And I've made this point before too, and it's important for the BDSM community to know, you cannot have prearranged agreements for what to do. You must have, like you say, contemporaneous at the moment. You must have consent at the moment.
But with Reimer and with TS, it is relevant now if there are prior discussions or prior written communications that lay out essentially a script of what you intend to do. That is relevant to the issue of consent or honest mistaken belief in consent. Full stop. Let me say this. In Reimer, God bless the Court of Appeal, at paragraph 74 said the following: I am also persuaded that the trial judge erred by accepting the submissions of the Crown and complainant's counsel that the earlier expressions of consent were not relevant as a matter of law because consent must be given at the time of the sexual touching. the contemporaneity rule. The rule has no application to the lines of reasoning I have described. Neither of those lines of reasoning depend upon the theory that the consent the complainant expressed earlier was the consent provided in the motel. They depend instead on the theory that her earlier statements of intention to consent are relevant to the question of whether she did, in fact, consent during the meeting in the motel. The Alberta Court of Appeal rejected a similar extension of contemporaneity rule in McKnight. The Alberta Court of Appeal commented, "This kind of error conflates the law of consent with the law of evidence." And the fact that consent must be given contemporaneous does not mean that evidence relevant to the factual question of consent must be contemporaneous. The complainant's words and actions...
You're using fancy words, Joseph, though.
Sorry.
So I know when
Just
when
let
you
me finish
I
it.
just want you to explain it a little bit more in layman's language.
The complainant's words and actions, sorry, you threw me off, before and during the incident. I want to say this. The complainant's words and actions, that's simple to understand, before and during the incident can be considered in determining whether a complainant has consented at the time of the sexual activity, so long as the earlier words or actions are relied upon because they have a tendency in logic and human experience to support the likelihood that the complainant consented at the time of the sexual activity. They are not rendered legally irrelevant by the contemporaneity rule. In my view, the trial judge misapprehended that rule, erring in law. Let's stop.
Can I summarize?
Sure.
You say you're going to do it, you probably did it.
Okay.
Right?
Yeah.
That's common sense. You say, why don't you show up and do this thing to me? And then you accuse the person of doing that exact same thing to you. You said you wanted to do it. More likely you probably did it because you literally asked them to do that.
So what they're trying to draw a distinction on...
What's wrong with that logic?
Nothing. Nothing. And finally, courts are recognizing it because Crown Attorneys and Complainants Counsel wanted to bamboozle courts for so long that consent is only relevant at the time that the act takes place, meaning the moment that you're having sex, each and every particular element of that sex, there must be present communicated consent. Yes, there does. But what they tried to say as a result of that is that everything extraneous to that happened before is irrelevant. So if the complainant had said in a message to you 1 hour before, I would like to engage in this type of intercourse with you tonight at my house, that is irrelevant and not admissible because consent has to be at the time. Okay? Finally, and we all knew this to be true, there are proper judicial statements, and we knew it from McKnight and from Reimer and now from TS, that's conflating two different ideas. Yes, communicated consent must be at the time of the sexual act, but words and actions prior to are relevant as to whether there was communicated consent at the time.
Yeah.
Have I made that clear?
More or less likely to be true.
Yes.
One of the things I want to point with this decision in TS that disturbs me a little bit, and it's a technical issue, actually, is that when they published these things, there's a whole bunch of redacted stuff. 8 words of sexual communication removed. 7 words of sexual communication removed. So they have a summary of what was being said in their rape play text. And then when people are trying to understand why this decision was made, almost every other sentence or a quote says 2 words of sexual communication removed, 7 words removed, 12 words of sexual communication removed. This is not helpful to understand why these decisions are made. And we've had a number of cases also where people have said that the entire appellate decision should be redacted and removed and not published. And it is so important for other cases.
Yeah, I agree.
It is so important for other cases that we can understand how they come to their decisions. And these redactions are not helpful. The complainant is not being named.
Right, because what you're talking about is we need
Sorry,
the full...
that was a bit of a rant.
No, but it's a good rant because we need the full wording so we understand the relevance.
Yeah.
Which
So,
then gives guidance to other
how do we
courts.
understand how they came to the decision when all you're reading is 8 words redacted, 12 words redacted, another 2 words redacted, we can't actually follow it and understand how they came to the conclusion. And I think this is very important.
But I think we can read between the lines pretty clearly here. So let's talk about this a little more, because this is just such an interesting fact scenario, particularly because of what you said at the beginning, that this is about a type of role play where it's...
Which is considered a rape myth.
That's exactly why I'm saying this is very important. Yeah. If you've been in criminal law, you know, it's trite to say that the absurd always happens, and it's not for us to say what people enjoy and don't enjoy. God bless them. If you do it in your own home, who cares, as long as nobody gets hurt, okay? But rape fantasy is real.
It happens.
Yeah. But it's real.
It's a myth to say that many women or all women have rape fantasies, but it's not a myth to say that some women do.
Well, men has it, but women don't. I mean, that's really what they're saying, right?
But so it's hard to imagine. But the BDSM community, exists, and the BDSM community covers a larger amount than just, domination, submission. It covers a lot of stuff that you can't imagine asking somebody to do to you, but people do it. And that's something that the legal system needs to understand. The reality is that people do things that maybe you wouldn't do, but it's up to them. They can make their own decisions about their sexual lives. And, there has to be some respect for that in our modern culture.
No, I agree.
That people do things that maybe you wouldn't do, but you need to understand it happens.
I 100% agree.
And it's not a myth.
And this is a perfect example. It's a very interesting case. So again, just to recap, there was no, dispute really about the nature of the sexual activity or the fact that the accused in this case didn't take steps to ensure the complainant consented at the time, but that was all because of the messages and all because of the very specific conversation that they had within an hour or two of the actual act, which was part of the scenario discussed. So importantly, the appellant testified that the complainant had agreed to participate in and indeed instigated a rape role-play scenario which explained his failure to ascertain the complainant's consent during the encounter. So the messages themselves, where we have certain content blacked out, were messages the evening before where they were discussing about sexual fantasy and role-play, which the topic of rape role-play came in. And then he testified that the messages were followed by a more specific discussion of a planned rape role-play scenario when he arrived at the complainant's home the following day, an hour or two before it actually occurred. The trial judge held that the messages exchanged between the parties the day before the offense were not relevant and were therefore not admissible. The judge accepted, as I said, the complainant's evidence and basically rejected everything that the accused said.
But they let in the messages from afterwards in which he says, "I'm sorry you felt raped."
Yeah, there's messages afterward, and there was clear animus. There was clear reason of animus. And I have to say, the accused who engaged in this behavior with that particular complainant
was stupid.
Stupid. I mean, you're just setting yourself... They were divorcing.
Okay? Yeah. He had custody of their children.
Yeah, and it's just mind-boggling. But anyway.
She had a lot of motive to try and get custody back again. But the scenario was that she was supposed to pretend she was asleep, and then he was going to come in and pretend to be a stranger. And this was negotiated in their messages.
Not as explicitly. This is where we have to be careful. The messages talked about, rape play scenario, and it talked about wanting to do things. You said you want to sneak in here. I'm sleeping. I still can't get that out of my head. And they're clearly having, sexting, and it's clearly about this particular scenario. And the day after, he comes, he testifies that he comes to the house. The individual in question is wearing a robe with nothing underneath. He gets flashed, and then they have this very specific conversation in the kitchen, which they call in the case the kitchen conversation. And during this conversation, the complainant told him that once the children were settled in bed, that she would go to the bedroom and they would start role play from there. Very specific, and it talks, and the conversation gets specific, essentially as to a script as to what would be done. And he thought, as in light of the text messages that were just before, that it seemed that they were actually executing what they were planning on doing.
There's a little bit of a conversation or discussion about what the judge had said in this case that I want to address, because they said the judge noted the challenges presented in this case to the concepts of consent and communicated consent. I'm on page 8.
Yeah, actually, this is a very, this is why I don't, I think the judge came a long way on this case.
Yeah.
I think the trial judge was trying to do a good job, but made a mistake here.
Leaving aside the French accent that shouldn't be on the word roll.
But read this paragraph, because
They
the
got
judge...
a little, what do you call that? I can't remember that French symbol. They got a little hat over the O and roll every time.
Somebody's going to criticize us for not knowing that. But anyways,
Well, no,
this is an important paragraph. Let's just
I was
focus on
married
the
to a
facts.
Frenchman. I should know. It's not anyway. The role play aspect of these allegations creates several challenges for the court.
Say it slowly.
So this is what the judge had to say. So the judge is being overturned.
Yeah.
But this is what the judge had to say.
This is a good paragraph.
The role play aspect of these allegations creates several challenges for the court. In the usual circumstances, a sleeping complainant is not consenting to sexual activity. Where the parties engage in role play involving fake sleep and a pretend stranger and pretend lack of consent, the fact of consent and its communication take on a much different complexion. Although advanced broad consent cannot amount to consent, in the context of role play, the court must examine the specific parameters of consent specific to these acts. This is different from broad advanced consent, unmoored from the specific acts themselves. When a person wants to engage in role play, in which their role is to feign sleep, to require an actual verbal form of consent in the moment, deprives the role player of the central setting of the role itself, namely feigned sleep. If the script for the role play is created in advance of the role playing, then the creation of the script itself and the consent to the script must be examined to determine if there is actual communicated consent. To hold otherwise would be to mean that a person cannot possibly consent to sex in the context of role-playing feigned sleep and or rape.
So good for this is why I said the trial judge went quite far here, and I commend the judge because they're considering, the nuances and the very careful analysis. So let's just say one thing. It's very clear that a broad advanced consent, unmoored, which is a cute way of saying, detached from the specific acts themselves, is not evidence that's admissible.
Right.
But in this case, the conversation...
They are moored.
They're very moored.
They're very moored.
The boat's f***ing against the dock, man. They're tied up at the bow and stern. How am I doing? I'm getting boat talked in.
You said do this, and then they did it, right? So that's very moored. It's very moored.
So it's very moored from the bow and the stern, and from what's the right and left called? Starboard. Okay. And I used to be a boat captain.
I know.
One of my most fun jobs.
I was a sea cadet.
Okay. So in the context, the trial judge concluded that the kitchen conversation was an integral part of the sexual activity that forms the subject matter of the charge. This is a very important statement. This follows Reimer as well. This is because the kitchen conversation did not simply relate to the complainant's state of mind at the time of the conversation, but rather specifically reaches forward in time to set the parameters of the role play. Or accordingly, evidence about the kitchen conversation was considered admissible without going through the 276 framework. This is a very important paragraph. And that's why I talk about Reimer and this case really extends to some extent the subject matter of the offense. It's really, and I just kind of argued this in a 276 application where the judge looked at me sideways. You're talking about the script for the specific act that happens an hour and a half later. It's really part of the subject matter of the offense. So the judge did a good job here in that analysis.
But ultimately failed in the outcome because the judge...
Well, we can't say that necessarily because we don't...
The Court of Appeal found that.
Well, failed in excluding the messages, but not necessarily in whether arriving at the conclusion of trial at the end of the day is right or wrong. We didn't hear the evidence. But the trial judge observed that the text messages did not contain any discussion of the basic elements of the script for the role play. So the judge determined that the complainant could very well have been talking about fantasy and shared sexual images and things of that nature. That is the error here. That is the main error here. And like you said, the messages afterward where the complainant communicates that you sexually assaulted me, that's admissible. We could talk about that at some length, but I don't want
But
to.
it's also a prior consistent statement, right?
It has limited admissibility,
afterwards, right.
but he actually responds to
So
say,
in
well,
this case, they allowed her to put in messages afterwards saying, I feel assaulted, but they didn't allow the messages saying, hey, can you please assault me?
right.
Essentially, that's what she said. Like, when you're asking for a rape fantasy, you're asking somebody to pretend to assault you.
So let's just review a couple of things so our listeners understand. So to get these messages in,
I'm doing this again. It's like,
blood pressure okay?
All right.
So to get these messages in, the threshold for evidentiary relevance is low. It has to be logically relevant. An item of evidence does not have to be firmly established a truth or falsity of a fact and issue. Evidence can also be admissible if it supports an impermissible twin myth, meaning a person is more than likely to have consented. In fact, that's what the it's treading on here, because they're talking about people following through with their actual stated intentions. So it's very important in these applications that the accused must identify in a detailed manner how the evidence relates to a permissible use that does not rely on twin myth reasoning. So it has to go to a direct issue. And here, of course, credibility and consent are an issue.
Let's do a simultaneous page turn.
Well, I'm going to stay on page 15 for a second. It reiterates, and this is important, that evidence of consent need not be contemporaneous in order to be relevant. It may consist of circumstantial evidence, including evidence of the complainant's words and actions before and during the incident. And that goes as far back as 𝐸𝐴𝐶𝐄, which is the seminal case on what consent is.
I'd say.
𝐸𝐴𝐶𝐄, whatever. Evidence of how consent... Tomato. Evidence of how consent to sexual activity was communicated in the past may be relevant to the issue of consent and whether the accused had an honest but mistaken belief in communicated consent. For example, prior sexual activities between an accused and the complainant may establish legitimate expectations about how consent is communicated between the parties. And this is in the Barton decision. Negotiations can be considered or predicated on a broad advanced consent to all sexual activity, but it can also relate to actual consent when you have, as we did in this case, fairly specific details of a script to follow. So I just want to skip to, because I don't know where we are in timing here. I don't want to kill our viewers too much, but I want to talk about why.
Well, it's just fun because, like, I know what
This
you're
is
reading.
good
I've read
stuff.
it too, but it's like, but we kind of have to break it down a little bit because sometimes the language is a little too technical, right? So, I think what the majority of viewers are saying is, what the like, how can this not be relevant? And it's like they're going on about context and this is what makes people angry when they read court decisions, right? That's what, I think this decision is important for a number of reasons we're going to get to, but the reality is we got with Crook common sense
back
again.
Common sense and logic. I gotta drive everybody nuts by reading from this a little bit. And Diane, I'm at page 16, so we can interplay. But
I'm on 17.
This is a really important discussion, and I want to give context to it because I think it's very important that for everybody to understand.
Yeah, no, it is, and and not just in reading from it, which it's important to read from it, and you can actually go online and you can read the decision yourself. But what I found is a lot of lay people go online and read decisions and don't understand what they mean. So I want them to understand.
We'll try and explain.
I want them to understand what it means.
So the Court of Appeal finds that there was no controversy in this case that the texts were evidence of sexual activity other than the sexual activity that forms the subject matter of the charge, because it was not speaking specifically about the script that unfolded the next day.
Which means, if it's not the subject matter, you must bring an application prior to trial.
Right.
In order to be able to even ask about it.
Okay. Now, the accused properly argued that the trial judge erred because in the context of role-playing involving fake sleep and a pretend stranger.
And fake sleep is in quotes because that's an actual thing that was said.
That's right. And a pretend stranger, consent in its communication takes on a much different complexion. Okay? If the agreed upon role play involves feigned sleep, it cannot be expected that a participant will verbalize consent at the moment the sexual activity occurs.
They literally had an agreement. She's going to pretend to be asleep. He's going to pretend to be a stranger. And then, of course, she's not going to say anything about, oh, yes, you can have sex with me, because that's their role play agreement. Okay?
So in this unique context, the conversations that occur in advance must be examined to determine whether there is actual communicated consent to the sexual activity that will occur within the role play. As the trial judge observed, this is different from broad advance consent that is unmoored, I love that, from the specific acts themselves. The accused stated that given the importance of prior conversations between him and the complainant, the texts were clearly relevant to issues at trial, namely consent and honest but mistaken belief in communicated consent. The issues around consent turned on the factual question of whether the appellant and, well, it's a fancy word for the accused, but on appeal, and the complainant communicated in advance about a rape role fantasy that would involve the complainant feigning sleep.
Okay, so most of the time, an accused is asked, did you get consent? How did you know you had consent? This is a unique circumstance in which the person did not seek consent because they were told not to. That was part of the role play.
That was the actual sexual act that they wanted to have fulfilled.
What if the accused person tried to go into court and say, oh yeah, I asked her for consent while I was in the midst of pretending to be a rapist? Would they be believed?
Well, just think about this case.
It doesn't even make sense. It doesn't even make sense.
When a judge logically excludes the messages, it's a problem. Because then you're just relying on his own self-report about what their discussion was.
And how is he supposed to explain why he didn't seek verbal consent? Because she specifically didn't want him to. That was their role play. That was their agreement.
So the messages, when the messages were exchanged, the accused and the complainant both anticipated that the appellant would be bringing the children for a supervised visit the next day. The appellant testified that in light of the text, it seemed that they were planning, what they were discussing was what they were planning on doing during the visit. Viewed in this context, the Court of Appeal said that the appellant was correct, that the trial judge erred in her assessment of relevance. The trial judge found that because of the November texts did not contain a detailed script for the role play, they were not relevant to the issue of consent or honest mistaken belief in communicated consent. However, it was wrong for the trial judge to view the messages in isolation. The question of relevance did not turn on whether the text, I'm using that interchangeably, standing alone, established that the complainant had consented to the activity. The question was simply whether the texts were logically probative of a fact that was an issue at trial. Here, the key fact in issue was what discussion, if any, took place prior to the sexual activity about a rape role play. That's incredibly important.
Yeah.
The court also found that the judge erred in failing to consider the relevance of the text in light of their asserted connection to it's important, to the conversation in the kitchen. The accused testified that the kitchen conversation represented a continuation of the one that occurred the day before in the messages. The messages were prior communications that related to the complainant's interest in engaging in the very specific type of role play that the appellant says when they discussed the next morning in the kitchen and carried out a short time later. Without the November messages, these text messages, for context, you'll explain why I say that, the appellant was left to testify. I'm going to repeat this. Without the text for context, the complainant was left to testify in effect that the kitchen conversation occurred out of the blue. I don't think the Court of Appeal said rather than as a follow-up to a discussion that the complainant initiated and participated in.
Right. So here,
stop and think.
Here's what I have to ask.
No, I want the hard copy.
Here's what.
Do you know how expensive printing is these days?
Here's what I have to
Paper's
ask.
going through the roof.
Is a rape fantasy a myth?
No.
Sometimes people actually ask people to do this for them. And how do you protect yourself against that? And this is a great decision in which it is important to keep in mind that women are different creatures than those of the 1800s, and they make weird decisions that maybe judges don't understand.
But I don't think we should say
Maybe you
weird
don't
decisions.
understand.
Here's the problem.
But
everybody,
we
I've
need
said this
to
before.
assess.
The courts and our government need to be careful about being in the bedrooms of our communities.
Yes.
And people are people. We are humans. Everybody has their own interests and predilections and desires and fantasies. Knock yourself out.
Yeah. And if women want to choose that, let them choose it.
If men and women, or whatever gender you ascribe to, want to choose whatever scenario you want to play in, God bless you, so long as there really isn't harm. But it doesn't mean that you can't consent to this.
This is a case in which they have evidence that somebody arranged for a rape fantasy role play. And what does it do to other women to hold her accountable to what she said and what she did? It doesn't undermine real victims coming forward, which is generally what these laws are designed to do, is to protect real victims. Well, just don't say something you don't mean.
Okay, so here's something that I'm going to harp on, and we'll end on, okay? Because it's a point of law and natural logic and common sense. We often have to argue in applications that a piece of evidence is relevant because it provides context to why an accused is saying something.
Yes.
And that term context has been vilified unfairly through other case law, purposely misunderstood.
They say it's like some sort of a inappropriate pathway to try and get improper evidence.
Narrative
in.
and context are dead. I remember one particular lawyer saying that, and I complainants counsel, and it was just disgusting. It's not dead. All it means is that piece of evidence has to be tethered to a relevant issue at trial. That's all. It has to be well grounded. Mm-hmm. So this is a very important piece of evidence.
Moored.
Sorry?
Moored.
More, yeah, I'm going to start using that. I'm going to go to nautical terms from now on. And I'll tell you the funny story one day. Like my favorite job in my whole life was at age 20, university. I was scared of water, and I got a job as a boat captain at Toronto Tours doing tour. It was the best job
Sharks.
I ever had. Anyways, no sharks in lakes, only in Sharknado.
Oh, that's true. I've learned that. Yeah.
Only in Sharknado. Okay, I just got to say this again. So the text messages were context to help explain why the appellant would testify and be more credible about a conversation that occurred in the kitchen 1.5 hours before the actual sexual act occurred. Otherwise, it might seem that it's completely out of the blue, or as we've said in many times, that the accused was being predatorial. Rather than, in this case, a follow-up discussion to the complainant, to the conversation that the complainant initiated and participated in. So just stop and think again. This was real-time evidence of conversations about specific role-playing that the complainant wanted to engage in, without the specifics, albeit that were actually discussed within some period of hours later, the next day, when he came over with the children. And we have this in other cases. It doesn't have to be about a rape scenario, but parties can communicate and say, I would like to engage in a sexual act with you in a specific way tomorrow or on the weekend.
And it makes it more or less likely to be true if they did or didn't say that thing.
And it's relevant to consent, but it's relevant also to the accused discussing what they talked about and how he knew he had communicated consent during the subject matter of the offense, because there are these messages about this fantasy play or role play, or actually discussions about what they really wanted to do. That's where the context is important. And to try and exclude this, and to continue to have Crown Counsel and Complainants Counsel, with all due respect, arguing that this type of context is harmful, myth-based, and irrelevant, does an injustice and leads to wrongful convictions, because this skewed the analysis. And frankly, in this case, on a retrial, there should be careful analysis on the motive to fabricate here, because this was it's probably going to be retried. I'm not going to go that far, but
Well,
there's definitely a motive
he's
here.
won his appeal so far, and
Good, and I'm saying good for the trial judge in that very nuanced analysis about something she's not, which may be, unfamiliar to most people. So it was a good analysis, but it did not go as far as it should have. And the Court of Appeal did a very good thing. But there's good case law on this, and I commend it for reading. And I'm out of breath.
And yeah, I know.
Can you do pillow talk? Because I'm tired.
Oh yeah, okay. Well, if you enjoy our podcast, don't forget to like, comment, subscribe, hit notifications so that you can get notified when our videos go up.
Share.
We do read our comments, and please share the videos.
Have a good night. Thank you very much.